Welcome to this explainer. Today, we're going to unpack the Supreme Court's incredibly dense draft regulations for artificial intelligence in the courtroom. We are exploring the really fascinating and honestly pretty contentious tension between technological promise on one hand and a flat-out legal panic on the other. I mean, as AI continues to just dominate the headlines, its potential role in actually deciding our legal fates has sparked some intense debate. Will it make justice faster and fairer? Or is it going to strip away the essential human element of the law? Well, let's find out. Here is our roadmap for the breakdown. We're looking at AI in the courtroom, the human primacy rule, guardrails for justice, the accountability factor, and finally, innovation versus restraint. It's the ultimate question on everyone's mind, isn't it? Let's just dive right in and address the elephant in the courtroom. With AI currently writing our emails, generating art, and literally passing bar exams, the natural next question is whether the ultimate arbiters of truth, our judges and juries, are next in line for automation. Part 1. AI in the courtroom. The hype versus the law. Okay, so let's get into this. We have seen massive global hype recently about AI stepping in to take over legal and administrative roles. Analyst Vijaya Shankar Naya actually points out that the Albanian government literally appointed an AI as a minister. No way, right? And major publications like The Economic Times have been actively recommending that companies adopt AI specifically so the army of lawyers usually required for compliance could just be entirely eliminated. So the hype surrounding autonomous AI taking over traditional human roles is absolutely at an all-time high. But hold on a second. The source text aggressively contrasts this massive public push for AI autonomy with a definitive, unyielding mandate for human subservience in the judiciary. Basically, there is a massive gap between what tech enthusiasts want AI to do, operating independently and replacing human jobs, and what these newly proposed judicial regulations will actually allow it to do. Under these rules, AI is set up to be nothing more than an assistive tool, period. Part 2. The human primacy rule, found in Chapter 2, Section 4. Now, this right here is what the author calls a mortal blow to the idea of AI taking over the courts. Section 4 explicitly defines human primacy. It ensures that AI in court processes shall at all times remain strictly subservient to human judgment. It mandates that every single AI system must function solely in an assistive capacity. It absolutely cannot supplant or even compromise the independent authority of a duly appointed judicial officer. So for anyone out there hoping for an autonomous robot judge, yeah, this section shuts that argument down once and for all. And just to put a final nail in that coffin, as the analyst points out, the text explicitly bans using AI to predict outcomes. The ultimate authority to determine matters of law, fact, and justice, that vests exclusively in human judicial officers. You can't just feed a stack of case files into an algorithm and ask it who's going to win or lose. That level of predictive judgment is strictly reserved for humans. So if AI is only ever going to be an assistant, how exactly is it regulated? Part 3. Guardrails for justice. Protecting the process. Well, to enforce this human primacy, the draft regulations lay out this incredibly dense protective framework of 12 distinct principles. Now, instead of wading through all 12 of them sequentially, because nobody wants to do that, we can group these key guardrails into a few crucial buckets. First, guaranteeing fairness. This means specifically designing AI to avoid bias and protect vulnerable groups. Second, upholding the rule of law and the established Bangalore Principles of Judicial Conduct from 2002. Third, strict data protection and privacy, which intentionally aligns with the Digital Personal Data Protection Act of 2023. Fourth, mandating really robust layered cybersecurity. And finally, ensuring data integrity. This means AI can only be trained on data that is accurate and lawfully obtained. Unlawfully collected datasets are strictly prohibited. So the really crucial takeaway here is that the use of AI must be proportionate to the risk. The principle of proportionality dictates that any high-risk AI application, specifically we're talking about anything affecting personal liberty or lawful rights, requires strict, mandatory human-in-the-loop safeguards. The higher the stakes of the case, the tighter the human leash must be. There is literally no scenario under these rules where an AI makes a high-stakes call in a vacuum. Part 4. The accountability factor. Closing the loophole. All this deep requirement for oversight naturally prompts a pretty big question. What happens when an AI tool makes a mistake or generates false information? We know what happens. Well, the text brilliantly closes a major loophole right here. It explicitly forbids judicial officers from blaming an AI's black box or hallucinations for a bad legal decision. If an officer uses AI assistance and issues a palpably incorrect, illegal, or harmful decision, they can't just throw their hands up and say, hey, the AI made me do it. No. The accountability rests entirely on the human's shoulders. This builds into a very strict linear workflow. Step 1. AI outputs are generated, but they are treated strictly as advisory in nature. Step 2. The human officer must use reasonable care to manually verify the accuracy of that output. And step 3, that human officer assumes exclusive accountability for the final decision. Now, there's a minor exception where purely administrative, non-adjudicatory AI tools, if they're certified by an AI secretariat, can be deemed verified on a class basis. But for anything involving actual, real judicial decision-making, the human owns the outcome, period. Part 5. Innovation versus restraint, the core paradox. This intense focus on human accountability brilliantly illustrates the central conflict running through this entire document. Section 17 of the text explicitly claims a presumption in favor of innovation over restraint, actively encouraging the responsible adoption of AI to reduce court delays and improve access to justice. Sounds great, right? Yet, practically speaking, the analyst concludes the exact opposite is happening. He states that restraint overrides innovation due to the sheer volume of rigid restrictions we just talked about. The regulations are just so heavy. In fact, the analyst throws some pretty sharp critique in here. He observes that the court appears to have been way more rigid than necessary. He suggests that the authors of these regulations likely worked under a state of panic, a deep fear that the judicial system might be completely overwhelmed by AI usage, which could, eventually, eliminate a huge chunk of human adjudication entirely. To prevent that dystopian future, they built this massive fortress of rules, so dense that it might actually stifle very innovation Section 17 claims to promote. Because of this super rigid legal posture within the formal courts, the author offers a strategic pivot. He suggests that tech innovators who are seeking to truly leverage AI should probably look outside the traditional courtroom. Instead, they should push for AI usage in alternative dispute resolution avenues, specifically mediation processes and with recourse arbitration. Why? Because these areas aren't bound by those strict formal judicial system regulations, making them far more fertile ground for testing out real AI innovation right now. So as we wrap up this explainer, we are left to ponder a really crucial question. The Supreme Court has built a massive wall to ensure human primacy, fairness, and accountability. But by prioritizing restraint to curb their panic over AI autonomy, will these heavy guardrails successfully preserve the sanctity of human justice? Or will they just prevent an already overwhelmed system from achieving the much-needed efficiency and evolution that AI could genuinely provide? It's a delicate balancing act, for sure, and only time will tell how these rules play out in the real world. Thanks so much for joining me to decode this, and keep seeking to understand the mechanics shaping our future.